Good afternoon, and thank you for joining us today. We hope, as you listen remotely, that you and your families are healthy. Thanks for joining Jennifer Schaus and Associates as we come to you live from downtown Washington, D.C. today in our COVID contracting webinar series. Our webinar series is created in response to the COVID-19 virus and the impact to federal contractors. We have created a COVID contracting section on our website, which has contracting resources and all of the related webinars for download. On that note, today's slides will be available on slideshare.net. As mentioned, the webinar will be on our website under the COVID section and will also be on our YouTube channel with 350 plus complimentary federal contracting webinars. Okay, so this is how it's going to work today. We will first share some helpful government websites that may be referenced in today's session. Again, our slides are available on SlideShare if you want to access the link. I will then introduce our speaker, David Dempsey, who will give a short presentation and answer questions. We will not take live questions, so please contact David directly. As mentioned, these next few slides are important links to federal sites which may be helpful to you. This is the SBA loan link. And FEMA's Defense Production Act, we have complimentary webinar on our site regarding the fine print and details. Information on this slide points to CISA. Tax relief and information here from the IRS. GSA has made significant changes regarding the Trade Agreement Act, so please visit their site for more information. Department of Labor updates are found here. You can also join us at 1 p.m. for a related webinar on paycheck protection and more. DoD information is here. The big OMB memo is referenced in most COVID contracting webinars. Our agenda is as follows, and we should wrap up by 12:45 p.m. The recording will be available later this afternoon, so please check back on our website, again under the COVID contracting section for this link. Today, David Dempsey, a government contracts attorney, will discuss the request for equitable adjustment and referred to as simply as REA throughout the presentation. We are not taking live questions, so please email David directly if your question is not answered today. David, thank you for joining us and sharing your time. The floor is now yours.
Thank you, Mallory, and good afternoon, everyone. I appreciate you taking the time. Nowadays, a day without a webinar is like a day without sunshine. So seem to be. But as you've seen this first slide that I've got, the background to the REA, I've got the to the third power after communication, documentation, cost segregation. That's because most of these articles and webinars talk about communication, etc. And that is definitely the case with any submission of an REA. And I'll be focusing on evidence for actual damages. And then with this COVID-19 pandemic, we have some remarkable one-offs associated with any REA that goes in to the government, any agency, particularly the time frames, because they have to match with your employee records. There's a big focus on small business. In fact, I believe in what I'll be talking about. There's only 1 or 2 times where there's going to be anything associated with a large business, and that'll be the employee retention credit. And then the simultaneous scope of the pandemic. The issue there, of course, is that everybody is more or less shut down unless you're working now on the essential business exception. And then the relevance of federal agency and state restrictions, of course, is very important because that's another time frame issue. Now, there are 2 objectives to an REA. The money, of course, is significant, but also the actual deal you do, because it's going to be a contract modification, which I'll be showing in a while. And that has to be properly done first because of the release language, so that you don't end up being prohibited from submitting any more REAs due to COVID-19. And second, so you can also get an idea of what the future costs may be that you have not incurred yet. That's all part of an REA package. So on the next slide, you'll see that are we at that next slide? There. The next slide I've got is a remedy granting provision. Every request for money in the government is going to focus on whether or not you have a provision in the contract that will allow you to do it. These are called remedy granting clauses. And I've got the basic ones listed there, which is the changes, stop work order, suspension. And then we have essentially two new ones. Excuse me, not new. What we have is one new one, the GSAR clause, and that's only been out about a week or so. In the DFARS clause, the continuation, if a contractor was turned on to do their continuation plan, that's a direct instruction, and costs associated with that would be charged to the contract as a change order, or cost would be charged to the government, and the government would expect it. Now, there are some remedies granted in the Section 8 once in a while, but most of them have to do with the time, and I've got an illustration there on the day-to-day extensions if the government causes a delay. Occasionally, a remedy will be identified in one of the Section J documents, sometimes in the SAL, sometimes in other elements of the technical elements of it. And then we have this, in effect, this statutory remedy granting provision, which is Section 3610. The value of 3610 we go into later on, and as a practical matter, I'm not sure it's such a useful approach. But before we get to that, let's continue on to the next slide, which is the mitigation of damages. When any contract circumstance you're in, if one party is harmed, they're under duty to reduce the harm to themselves and to the other contracting party, and that's just basically called mitigation. And an REA is going to have to describe what the contractor did, who's requesting the money, and identify any credits. And credits is apparently controversial in Section 3610. I'm not so sure it is, because it fits well within the FAR 31.205, excuse me, 201-5. It's part of material cost principle. But at any rate, I'd look at these credits as mitigation. And then keep in mind that we've got a statute that says, with respect to certain labor costs and such, that is going to be credited. We have a certification. DOD has already come out and said it's not a Contract Disputes Act certification. It's just a knowledge and belief, best knowledge and belief. And that is normally what I've always done with REAs without making too big a deal out of it. And I've never had an objective, no one's ever objected to it until we turn it into a claim. Now, if you don't have a remedy granting provision, then you have to go to the constructive change, the de facto stop work order, the de facto suspension of work, and that's where the phrases of delay, disruption, intervention, and acceleration, if there's some work that's accelerated because of this COVID. And then we have extraordinary contractual actions. the 85-804, and I wouldn't put too much faith in that without knowing the circumstances. But that's not likely to be the normal or close to the norm for trying to get some type of money out of the government. Okay, now the next slide, we get into the CARES Act 3610. And it's got quite a few elements to it. And as a consequence, and it almost seems to be describing a intelligence community contract, some high level of security clearance. The available appropriations part is, first of all, straightforward, and then second of all, there's a workaround on that anyway, which the government sure knows about. Now, getting to that, it's basically a judgment fund. The statute applies to any federal agency, so even though DoD has the most guidance out, every agency is subject to the CARES Act 3610. And then we've got what can be billed. That's the minimum applicable billing rate. And that may lead to some kind of controversy because minimum and applicable don't tell you whether you're in the base year or the third year. And of course, the rates change by then. And then there's a definition, there's a reference to paid leave, and that is the normal paid leave that comes under the cost principle of compensation cost principle, which is 31205-6. Ready state has been defined as by the DoD guidance and a little bit by the GSA and the DOE guidance. And that just means employees are ready to go back to work. The other ones, the affected contractor, that's statutory language, and there's a little controversy there on whether or not affected contractor status has to be obtained before an REA is put in, or whether it's a function of the REA, where that would be the threshold decision of the contracting officer. Because if you're not affected, then he or she does not have to make any, doesn't have to go any further. And then we have the elements to what an affected contract is. And then again, at the very bottom there, we have a time frame, January 31, September 30. That September 30, of course, to some extent, at least in the statutory writers' minds, has something to do with available appropriations. And then we talked a little bit about credits already. And again, that is mentioned in the statute. So that is going to be an element of any REA that is submitted with 3610 in mind. And then here is what the only serious implementation of the CARES Act exists: DoD, GSA, and Department of Energy. And you can see GSA's deviation just came out in April 21, and that DoD's last update on their FAQs was April 24. So this is going to be, for all agencies, this is going to be an evolving document that is going to have to be looked at for purposes of an REA, simply so you can make sure that when you given the narrative of your circumstance, you can give it in the context of this guidance. Okay, so now, pretty much the rest of this, for me, is going to focus on the preparation. I'm not going to try to tell you what DoD has said versus GSA or DOE, because I don't know what agency you might be focusing on for purposes of your particular REA. Nevertheless, those documents, those implementation documents are going to be critical, and until we get facts of what would be going on, it's going to be, I think, be a waste of time to go over those. You know, on this next page, you've got preparation of the REA and the factual background. And at least in my experience, people want to say, what do you know? What do you want to know? And I say, just please give me a chronology of everything. Now, in the REA on what we're having here with COVID-19, I would probably start a year. Right now, Section 3610, for example, is from January 31 to end of the fiscal year. So I'd go back to January 31, 2019, so that you have an idea, and the contracting officer has an idea how things were moving along then, and you'll know by your own records. And this would be the any emails, time entries. The DoD guidance and common sense would tell you that time entries is going to be an element of any REA. It may not be part of the submission, other than a an attachment. I don't know if you're talking about 5 people or 490 people, and I can assure you, no one's going to want to look at the time entries for 490 people except for some DCAA or DCMA person, but we can't do anything about that now. We'd have to work out with a contracting officer. So we want contemporaneous details starting from the relevant time period of your REA and probably a little before. A lot of contractors were talking to their program manager or their contracting officer in February as things started to make the news. Anyway, so you want to have that, and then labor, material, G&A. The G&A is going to be, excuse me, the labor cost is not the wrap rate to me, because that would include profit, and there's no likelihood that you're going to get profit on work that was not done, to say the least, even if you had a firm fixed price contract and a lump sum price and that sort of thing. That will normally be carved out. And then on the absence of unallowable costs, I would say you have to explicitly state there's no unallowable costs here. And then I'm giving you this 2019 MRD that which is Memorandum of Regional Directors from the DCAA. And you'll note that date is May 14th, 2019. So that is the 3rd revision of that particular MRD, which means they are paying attention to it. And as many of you already know, it doesn't mean they're right, but it means that's going to be they're going in position. And by that, I mean the government contracting officer's position. And then the time frames is we're probably going to need a graphic showing your performance, what levels, etc., and what happened graphically as various state orders came in for staying at home. Now, government contractor should be an accepted an essential worker under virtually all the state orders that I've seen. And then, so you don't have to get into the notion that you are an essential worker and had to keep going. But you'll see, and then I've got all the state orders, so that's easy to put together. But again, that's part of the time frame. So you go to the next page, next slide, where you've got subcontractor facts. And this is something that if you've got a contract that requires a lot of subcontracting, whether it's to an independent contractor or another company, you're going to have their damages in your REA, and therefore you should probably put together in effect a sponsorship clause, which has to be carefully worded because the sponsorship provision is subject to the so-called Severin doctrine, which means that the prime contractor is liable to the subcontractor in order for the subcontractors' damages and numbers, etc., can be ruled on. So if you have a paid when paid clause, etc., in your sponsorship provision, and the government gets a hold of that, you may have some of that money, you're likely to have virtually all that money tossed out from any subcontractor that you're working with. And then one big part of the story, I think, is you want your electronic records to be credible. And in my experience, the contracting officers are familiar with Deltek, QuickBooks, Uninet, and their systems. And then if you have a DCAA approved accounting system, then you're in better shape because the CEO, contracting officer, now knows he's got a basis to be reasonable. And you want to give him a basis to be reasonable. And keep in mind, this is a big difference between a claim and an REA. An REA, the cost of those preparation is an allowable cost. So that's part of your package. It only has to be reasonable. And there's a cost principle on professional and consultant costs, as you can see, but there's a lot of elements to that. DCAA has gotten very upset with those types of consultants and stuff. So you have to have an agreement with the consultant. And that's talking about a lawyer, talking about an accountant, and maybe even an actuary, given how long some of these may go on. But an IT person, et cetera, all those professionals that you're hiring have to have an agreement. It's got to have a scope of work, and it's going to have a list of deliverables. It doesn't have to be an elaborate agreement, but it's got to show that it's going to come within the professional and consultant cost principle. And then I went to the contract audit manual, DCAA's contract audit manual, which I do quite a bit. And there they specifically say that REA preparation costs are allowable. One cost that you want to be sure to have in there is the management time that company puts in. And all this sort of stuff, as you may know from prior understandings of DOD's guidance in particular, is you're going to have a cost principle, a cost accounting element where it says COVID-19 whatever. Would be COVID-19 labor costs, COVID-19 management costs, consulting costs, etc., whatever it's going to be. And then these last element there is the next element is the mitigation, and government calls them credits because that's what the statute says. You could call it offsets, whatever you want to call it. The word credit shows up quite a bit in the cost principles, so it's a fair statement to have that word in there in the 3610. And then we have contract modifications, and that's the SF30, and that's what I had in the first slide. Is the part of your REA to me, and I found this useful, is to draft
draft the language for the SF30. So that's going to be important later on when you may or may not want to make another REA. And keeping in mind that DOD looks at this section 3610 REAs as a one-off, one time can you ask for that. So this is, if you're going to be thinking of using 3610 and qualify for it, then I would not rush it because you may be leaving out various other costs. Okay, now we go to the next page. This is where I start having a little fun. And that is got the statutes and the OMB guidance, which legally is irrelevant, but it'll be useful to the REA just so you can have it sort of in your introductory paragraph. So please keep that in mind. The CO is only going to pay attention to their agency guidance. And what the OMB circulars are is talking about how we're all in it together, et cetera, and that sort of stuff for small businesses, et cetera, but it has no legal impact at all. The next slide, we start getting into some Labor Department guidance, because I'm going to be focusing on labor and taxes as the credits. Two things on this slide that are relevant to you, or particularly relevant, is the third bullet, which is the Q&A. There was 88 of them as of last night, and they're very detailed. And then the next one is that the Labor Department has already issued regulations in the Federal Register, so, and they're temporary, but they are in the Federal Register, so there are the sites to get to, including their correction, and you'll have to look at that. As Mallory said, following my presentation is another one on labor law. And I don't know what they're going to talk about, but that could go into anything from privacy to these particular regs. And I'll show you in a minute why they're important to you, at least in the context of trying to get these tax credits from the required leave, as it's sometimes called now. And that starts on the next page. The next slide starts out with the Emergency Paid Sick Leave Act, and it's part of the FFCRA. And you see another time frame there. So that's the time frame for those dollars. And if you keep in mind that this is for section 3610, this is going to be relevant to the one time you can put in your 3610 REA. I'm not sure you will. I think there's better ways to do that, but I'm not sure everyone's going to qualify the way they think so, the way the writers of 3610 thought. And then we have some details associated with the records you'll have to have if an employee chooses or elects to take some of the paid sick leave. This is details, of course, and your records should be reflecting this now. If you have had that incident happen, you get a regular rate of pay under 3 circumstances, and then there's caps on it. And caps mean reimbursement from the government. As a practical matter, they probably mean caps on what the employee will get also, but that will depend on the employment agreement, how much work or whatever they're doing. But at least in the regulatory scheme and in the Department of Labor's Q&As, they're quite specific about the 511 and the 5110. Then we have, again, 80 hours at 2/3 if the reason for taking the leave, and this is paid sick leave only, not the emergency, not the expanded FEMLA. So you're going to have to know why the person is taking the leave. And the regs that I've cited, these new regs, specifically say that this is what they specifically identify what the employee has to tell you. Because if they don't tell you that, you don't have to give them the leave. So I'll go on to the next page. And these are just a quick explanation of some of the so-called credits. And these credits here are going to be relevant whether or not you're going under 3610 or just filing a what I call a traditional REA, although the traditional one in this case is pretty much skewered by the COVID pandemic. And now we have the emergency family or the emergency FEMLA expansion. And again, we have 2/3 that are not working, 200 a day, and the 12,000 comes from the extra 12 weeks that someone, if they're otherwise qualified, would be able to get. So that's different than the 5110 that we had on the paid sick leave. In the regs that I cited, the covered employer gets a dollar for dollar reimbursement for tax credits, which includes applicable qualified health plans and other things. Those are details there, which would be something that the record keeping system and the accountants would work out. And note where I've got that the employer is not required to provide leave if the employee does not provide the requisite documentation. And that's important because without that documentation, the employer will not qualify for the tax credit. And then in this case, and this is another definition, a covered employee is going to be an employer, is going to be someone who's a small business and otherwise engages in commerce. The other part of that definition refers to the federal government because these two labor laws apply to the government as government employees as well as private employees. Okay, on the next slide is the IRS guidance. I've listened to 3 webinars on this element of COVID-19 regs, and beats the hell out of me what some of this does. Some of these accountants get into extremely detailed explanations, but I was able to say that as of yesterday, IRS had given out 8 notices, 7 revenue procedures, tax tips, COVID tax tips, and 13 FAQs, not 13 questions, 13 separate FAQs for one separate the IRS is going to be looking at for purposes of making sure that any tax credits you're taking are taken correctly. Okay, so on the next slide, I went into I identify, I guess, the 4 that I could easily understand. And the employee retention credit is something that all businesses get, not just small. But note again, we got time frame here: March 12, January 20 to 21. So that's different than the laborers. That's different from what 3610 was saying, et cetera. It's a different time frame, and that has to be in your REA submission if you're going to try to claim that, because that would be a credit that the government wants to know about. Net operating losses, the only thing I could say there is go see the revenue procedure, because that goes back 2 years, and you have to have net operating loss first. On the deferral of the employer's Social Security tax contribution, all that's happening is you got to identify the period. The wages were paid in March 27, which is different from March 12 up above, and ending December 31 versus ending before January 1 for the ERC. So that's what they get, and then if that has a value to you in claiming that, and it can be identified in dollars, then that would be a credit as far as the IRS is concerned, and as far as a contracting officer would be concerned. And then on corporate tax returns, there's a refundable alternative minimum tax credit. And that will get me away from two areas that are more or less identified in the CARES Act, which gets you back to the Family First Coronavirus Response Act, where these credits are identified. So in the preparation of the REA, keep in mind what you're not going to be covering, or what you may not cover, and you may not cover them because you don't know if it's an incurred cost or not. Some of it will be. For example, telework. If the government told you to gear up for telework, then that's an instruction that you can essentially take to the bank, put in the REA. And in fact, the Washington Headquarters Service, in their guidance to government officials, they said, we encourage telework, but be careful before you direct a contractor to set that up. So that telework is may not only be actual communication capability, but it could mean the cost of cybersecurity, and it should be, a cogent telework system is going to have some pretty good cyber with it. At any rate, and there's some other costs that COVID-19 may have caused, which you want to keep in mind, because you want those costs specifically excluded from the modification. Remember, you're going to have a release clause in that modification, so I want to make sure you identify what you exclude to the best of your ability. That's why you don't exactly rush into these. So now we'll go to the questions, which came in over the past couple of days. And as you can imagine, the first question is how long do you think it will take? And you already know what my answer is that it depends on the quality of the submission. You need to have trustworthy numbers, a cogent explanation, a detailed explanation. The reason for the detail here is twofold. First, so you'll speed up your REA, and then second, because the CO is going to get audited also by IG as a fact of life, just like contractor has to worry about getting audited by DCAA, and then the usual false claims and all that kind of stuff comes to the minds of the lawyers anyway. But the point being is that a cogent explanation lets the IG person know that the guy, the CO, was reasonable. And that's all he or she has to be for purposes of passing an audit. And in particular, they're going to focus on the evidence. And this is where pre-submission communications are going to be relevant to you if you can get the CO on the phone or by email, so you can get sorted out. And in particular, if you're going to use a 3610 REA, or that's going to be part of your package, then you want to sort out that affected contractor status, I think, well before you submit it. And of course, that has to be in writing, and it has to meet the qualifications identified in the statute. So all that being said, I would say a minimum of 6 months and maybe longer, whether or not it's below or above 500,000. It's above 500,000 in the several millions, and of course it'll take longer because that assumes that you're going to have more detail associated with the labor cost. And then the next one is what I've hinted at.
David, I'll go ahead and read these so that way we can read them out. And just remember that we have about 8 minutes left, so we'll have to go through these next 5 of those questions pretty quickly.
Okay,
so the second one is, should I submit a separate REA for incurred costs that are not subject to Section 3610 credits from the FFRTA, labor cost taxes, or should I combine all the incurred costs into one REA?
Yeah, and my answer is to combine them all to the extent that you know them. And that answer, of course, is consistent with what the DOD's guidance is with respect to the one-off on that Section 3610, as well as getting all your costs in, because the sooner you get something, the sooner you get a good REA in, the sooner you'll get some money. And most of the negotiations should focus on details and focus on the language of the modification itself, the SF30. Okay, I'm sorry, Marilyn, you want to read the next one?
Sure. So the third one is, please touch on the DoD issued FAR and DFAR class deviation on Section 3610 of the CARES Act and Section 3610 of the CARES Act for the FAS indefinite delivery vehicles, GSA schedules, GWACs, etc., regarding adjustments and reimbursement.
Okay, now my suspicion was that the person who asked this question was not aware that GSA had issued guidance on this. And the basic guidance for purposes of answering this is that, 1, you go to the GSA's guidance, and 2, which covers explicitly these indefinite delivery vehicles. And then also, the other part of the guidance that's relevant is that the decision making goes down to the task order level, as I would put it, task order level, for purposes of who's going to make these various decisions. That's explicit. GSA guidance, unlike DoD at this stage, one of the definitions or one of the requirements in the 3610 was that you be in an approved facility. And GSA says wherever you're working is an approved facility. So we're past that part with GSA. Different from the affected contractor status, but we're past all that. GSA's guidance is about 12 pages, so it's sufficiently detailed to provide some good answers to that question, other than what I've just indicated. Okay, then what's the next one, Aria?
Okay, so the first question is, will our PBR provisional bill rates and FRPA's for rate pricing arrangements require changes?
Well, that is a pretty good question, obviously. And my answer is, I don't know, because I don't know the details. I know that the Part 42 of the FAR is going to on PRBs and FFR, excuse me, FRPAs is going to say something about whether or not you should be doing a direct, excuse me, if you're going to charge these direct or indirects, then there's going to be a change. And some people think that if you direct charge all the COVID-19 time, then there's a good chance you don't have to change too much. And that is a big burden lifted away from the CO. But it seems to me, even if you direct charge it, you're still going to have to identify, you know, the so-called idle time, and then maybe, or I guess likely, segregate that idle time to anything that may have affected other contracts. Again, I don't have an answer, but I think my suggestion right now as a general response is that COVID-19 time should be looked as a direct charge for purposes of accounting to keep track of who and where is what, because this is on a per contract, per employee basis. And the provisional billing rates and the forward rate agreements are going to be, you know, focused on that base for purposes of those agreements. So I would suggest you start out with the direct charge and then see what happens, see how that works out, and you may make a change. We don't have too much time left, but go ahead with the next one, Mallory.
Great, so we'll go ahead quickly through these last two questions, which is, may contracting officers unilaterally reduce or deny REAs based on section 3610?
Yeah, they can't do it arbitrarily, but they can deny it. And I think a lot of them will, because if we go back to the availability of funds, then the statute also says availability of funds from any source. Well, the judgment fund is a source. And because of that, and then you get to the judgment fund by filing a claim and getting a docket number. And then you, and then that's the deal with it. I've done that a couple of times now. We file the claim, and then a CO can take it from the judgment fund, and then 3 to 5 years later, the judgment fund and his decision or her decision catch up, and then the agency deals with it then, which may not be a bad way to do it, but keep in mind an REA and a claim are different. REA costs are allowable, claim costs, i.e. litigation costs, are unallowable. So whenever you're talking to anybody, don't use the claim word until you're well into negotiations, or you're going to risk having all your prep costs be unallowable. What's the next one, Mallory?
All right, so the last question is, assuming that section 3610 focuses on labor cost reimbursement, what other types of events that resulted in contractor expenses would come under the REA?
Well, there's a lot of things. The cost of idle labor other than time is one, maybe some idle equipment. The costs, because there's a change in the workflow sequence, basically workaround. These are efficiency costs, in fact. And then the cost of ramping up and ramping down. Ramping up is costs that should start being carefully looked at over the next couple of weeks. Cost of training, the cost of OSHA compliance, and keep in mind a lot of your employees, if they're on a government facility, they're going to say these aren't safe for COVID-19 reasons because the government facility is too old or no windows, etc. That sort of stuff. So there's plenty of other events that are going to be other than the labor costs, and certainly other than reimbursable labor costs, reimbursable in terms of either PPP or the tax credit under 3610. So is there any other?
I think that those were all of our public questions. If you have any questions, please reach out to David directly. David, thank you for sharing your time and knowledge with us, everybody. Thank you, everybody, for joining us. This concludes our presentation.
Thank you, everyone. Take care. Stay safe.